Hey, it looks like it's the three live stream amigos right now. Three Zoom call amigos.
There you go. Good morning, gentlemen. Actually, it's only Kevin.
Oh, Detroit. Are you calling Detroit not a gentleman, or is that?
No,
just
I think Detroit
stream?
is just a live stream.
Oh.
So really, it's a live stream of Kevin and Eve right now, I believe.
It's the Kevin
Hello,
and
world.
Eve show. Do.
And I've got my EOS Asia pajama. I've got so many of these pajamas.
Hey, I want some pajamas. I wore an EOS Meso shirt to an interview the other day. They're like, wait, did you move to EOS Mesa? I was like, no, I'm just showing some Block Producer love.
Yeah, showing some love. My wife even has a bunch of different shirts at this point. She's got the I Was the AVP shirt.
That is one I'm missing. I need that for my collection. I got Rio, Canon, Meso, Shios.
I lost my Shios. I got a Shios, which is the best one because the Shios shirts are the best quality. And I went for an interview and I forgot it on the couch at the interview when we did the Acro EOS interview.
Oh,
I never got my shirt.
Sorry that you lost it.
All right.
You want to hear how awesome the breakfast sandwiches I make? Oh, there's more people now. Okay, I'll shut up.
Yeah, there. I'm having pancakes. My wife made me pancakes this morning.
No, Kevin, if you can please tell us about your sandwich.
It is spicy guacamole, ham, and Canadian bacon. Or sorry, that's the same thing. Egg, Canadian bacon, and spicy guacamole on an English muffin.
Nice. So I guess we have Josh that called in from his cell phone. So everybody knows, world, by the way, because this is being live streamed, that Josh's number is, and just look on the screen. If you want to call Josh's private cell phone. So maybe, Josh, you want to change your name?
Hello, guys.
I'm nothing to hide. Sorry, is anyone still there? I'm just not hearing anything. I can't see the screen.
I'm still here. I just turned off my video.
Okay, thank you.
So that you guys wouldn't see me eat my pancake.
Is that only on your paid Zoom channel?
Hello, everyone.
Good morning, Stephen.
Hey, good morning.
Or
Hey.
good evening.
It's just over midnight here.
All right, so.
I think it's just over midnight for Amy as well.
Which time
Oh,
is
really?
it, Amy?
But in a different direction.
Hold on, let me just get my audio paired. 1 second.
You're good. We can hear you.
Hey Achilles, how's Rome? How's Italy?
Great.
Nice.
Achilles, we're still waiting for the pictures.
What? Pictures. I see. I can shoot. There are a lot of beautiful girls here. The Roman girl, Italian girls are very beautiful, and some European girls from the French, German, and Holland. Those girls are very, how to say, beautiful, gorgeous. Yeah, gorgeous. A lot of beautiful girls.
And why are you still single?
I think I will resolve this problem soon. Maybe just 1 week or 1 month. Yeah.
Nice.
Steven, please, just so you know, this video might be recorded on live stream. So, but
Right now this is being live streamed.
Oh, Achilles.
Amy, should we get started, or should we wait for more more meeting participants to join?
Oh, there we go. Hello, everybody.
Good morning.
Stop, Amy.
Hey, Amy.
Good morning. Great. So I know that there was another call ending at 7:05 and that people were joining after that. Who from EMAC is asking the questions today? Is it you, Stephen?
I think it will be Shane, our president.
Oh, okay. Got it.
Amy, whenever you're ready, we can get started.
I'm ready.
Ah, you're ready. Okay, sorry. I saw we are waiting on you. So, yeah. I guess welcome everyone, and hopefully the previous session with EOS Alliance has already ended. So most of us has joined from the previous meeting. So welcome everyone. I think this is probably the first joint session we have had with between EMAC and Alliance, in particular the working group dedicated to the dispute resolution and arbitration, which is essential and critical for the task that we are focusing on, in particular for EMAC as well as in the English-speaking community, ECAF. So a lot of our community members and EMAC members have studied the RDRs that's current in the being used and being used by the ECAF, and we have studied and also a lot of us has dialed in and listened to the expert course offered by the working group, including previous weeks offered by coding rules, which is very very useful and very helpful. So this week we have the honor to have Amy to join the call and answer questions and if answer questions to our EMAC members. So Amy, why don't you start by give a brief introduction to the dispute resolution and arbitration group working group. This way, our members can and also the meeting participants can have a little bit think about their questions.
Sure. So the EOS Alliance was basically started to create a focal point for the community to be able to have these types of discussions, because otherwise it's just, a little bit more unorganized. The EOS Alliance has a board, right? And then under the Alliance, there are several working groups. So there's, for example, a constitutional working group. This particular working group that I chair is the Dispute Resolution and Arbitration Working Group. And so our mission here is to basically engage the community and really try and listen to the community and figure out what do they want. At the same time, we have recruited a whole host of experts on different aspects of dispute resolution and arbitration. And those are the folks that we've been doing community calls with over the past couple of weeks, and there's still a couple more that have to be done. And so our aim is to listen to what the community wants, but also talk to the experts and ultimately hopefully come up with findings and recommendations on how dispute resolution and arbitration should look on the EOS network. Just a little bit about myself. I'm the chair of the working group. I'm an attorney by training, started my career in the U.S. federal government doing international regulatory affairs. When I live in Los Angeles, California, so when I moved from Washington, D.C. back to Los Angeles, I became general counsel at a real estate crowdfunding startup. I've also been partner at a law firm, and now I run my own legal technology blockchain startup called Sagewise. And I got recruited into all of this because we actually build and focus on dispute resolution infrastructure for blockchain and smart contracts.
All right, very cool, very good introduction. So yeah, so I'm just gonna open the floor to everyone who is on the call. If you have any questions, just open your microphone and speak directly and ask our guest speaker here, Amy, today. So let me see. All right, so why don't I start with a question first? So
sure.
So we have been talking about basically arbitration or dispute resolution on the base layer of the EOS network. Can you briefly describe what is a base layer dispute resolution, and what is the difference between base layer and maybe the application layer, the app layer dispute resolution? Give us a little bit introduction there.
Yeah, sure. So basically, and again, all these terms are basically made up, right? And so I agree with you. Maybe it is nice to sit down and actually define them. So basically, the whole idea of a base layer is the question of, do we want default dispute resolution when the parties have not chosen it themselves, right? So basically, whenever someone is entering into a smart contract, for example, or whenever they are undergoing a transaction, if we have the dispute resolution not as a default, then in order for the parties to have dispute resolution, they would have to proactively go and do something that says, hey, we want dispute resolution, whether or not that's coding something into the smart contract or actively agreeing to it in the English or Mandarin contract or something like that, right? If they do not do that, and you have to remember that regular users, they're very lazy, sometimes they're unsophisticated, sometimes they forget. They want very easy transactions and as few clicks as possible. But to the extent that they do not specify that they want dispute resolution, then without a base layer, it means that they would have no recourse. So if anything went wrong, let's say, I bought a wedding dress from China or something like that, right? If the wedding dress gets here and it's too small, or it's the wrong color, or they shipped it to somewhere else, or something happens, then if I didn't pre-specify something, then I'm basically out of luck. So, if we have to kind of go back to our roots of why are we even talking about this, the reason why we're even having this discussion is because the EOS blockchain is trying to be the first governed blockchain, and its entire purpose is to be able to become the blockchain for small businesses. Well, when do small businesses do business? When do they transact? When do regular people transact? They transact when they feel confident that they will get what they actually want, right? And so the important term for everyone to know here is transactional confidence or transactional certainty. You have to think about it in the sense of, if someone is a small business and are they going to want to do business in an environment where there is no recourse, or where there is, some default level of recourse for them?
Sounds good. So essentially, it's really whether we want a default layer of dispute resolution to give the business and the enterprise level of confidence to do business on the EOS blockchain. Would that be a kind of fair assessment?
Right. And I do want to take a moment and clarify that we have to separate the concept of a base layer from, the base layer as proposed today, right? Because, I think I've talked to a lot of people in the community now, and I haven't met anyone who disagrees that the RDRs probably need to be redrafted or rewritten, because it is silent on a couple different, I think, very important features, right? So I think when we are having this discussion around base layer, we really need to talk about, the concept of a base layer itself, not necessarily as it's drafted or written in or proposed in the RDRs today, because the reason we're even having these discussions and these calls is to engage the community in thinking about, well, if we do have dispute resolution as a base layer, what do we want it to look like? Not what does it look like today?
And Amy, maybe you could speak to in situations where there's no base layer and it becomes the responsibility of each user to ensure that he has an arbitration option at the time of entering into the contract, that most experience tells us that there ends up being no pre-agreed arbitration. That in general, without a base layer, you end up with nothing. And that's certainly been my experience.
I mean, all you have to do is look at Ethereum, right? Ethereum does not contemplate a default, dispute resolution system or base layer. And so in EOS, without a base layer is basically a faster Ethereum. That's all it is. And just to throw a statistic out there, I mean, I don't know how much the community follows, transactional confidence or certainty on the Ethereum blockchain, but, there was the DAO hack in 2016, and that resulted in a $50 or $60 million loss in 2017, just from public reports, not even ones that weren't reported, over the equivalent of over $1 billion was basically lost on the Ethereum network because they have no default base layer. Eve, I see you have a question.
Yeah. So do you know if there are any statistics? So regardless of blockchain, do we know if there are any statistics in terms of human interaction and when humans have to opt into systems? How often do they actually opt in? So in this particular instance, if we were to have, let's say, opt-in insurance or opt-in bonds, opt-in protection, essentially. Do we have any statistics, or do you know of any statistics from regular marketplaces? How many people end up opting in because you're adding that one step? I know that, for example, the Canadian government had done these research, completely unrelated style of topic, but in Canada we have opt-in organ donation, whereas I believe I think it's Spain, I'm not too sure, where by default you have organ donation and then you need to opt out. And the level of participation in both systems is significantly different. And I know that there were other researches done in terms of marketplace. When people have to opt out, that one extra step they typically not do, and they don't do. And when they need to opt in, that one extra step they just typically don't do. Do you know if there's anything out there in terms of statistics that would show that having it at the base layer means that everybody's really protected, when we don't have it at the base layer? Sure, it's available, but people don't do that extra step.
So I don't have any statistics on hand to report as of the second, but I think you just have to go and look at examples in everyday life, right? So for example, in the US, when it comes to privacy laws, when it comes to can we add your email to this email list, the US is an opt-out system. So you're automatically in it. And if you don't want, marketers and data people to be spamming you with email and collecting your information, you have to opt out. And you can see in the US that very few people take that extra step to opt out. Whereas in the EU, privacy and, that kind of stuff, it's an opt-in system. And so at least the way it works over there, it's much harder for people to take advantage of other people's data and things like that over in the EU. Just think about when you're buying plane tickets online, right? You go, you buy your plane ticket, and then they're offering you, that travel insurance, cancellation protection or something. How many times do you actually go and, click the box to proactively buy insurance? Very seldom, because when normally when human beings
for travel sites, the uptake rate on such insurance is less than 1%.
Right. The thing is, when human beings transact, unless you're an attorney, I think you do not immediately think in your head, oh, something might go wrong, right? And you really only buy that insurance if you're thinking, oh, something might go wrong. Maybe I'm going to get sick or something. So same thing here. If you're entering into the transaction and you're already thinking something's going to go wrong, you're probably not going to do the transaction anyway. But you can never tell when something's going to go wrong. That's the problem.
Thank you, Amy.
And Stephen, I see you have a question.
Stat.
I think Stephen has his hands raised up. Stephen, do you have a question?
Yeah. Thanks, Amy, for clarifying. I just wondering what stage we're at. Are we still deciding whether or not we need a base layer? And if so, if we need a base layer, what basic principles that when we structure the base layer, or what the direction of this base layer?
Yeah, I think different parts of the community are at different stages in the discussion. I know that there are certainly still folks out there who, especially the token holder community that doesn't tend to put for example, as many hours into sitting here studying this problem, right? I know a lot of them still don't even know the difference between opting in and opting out. What is this base layer thing? I think for folks like you and me and maybe some other folks on this call who, have lived and breathed this problem for several hours a week over the past couple of weeks or months, a lot of folks are definitely on board with having a base layer, but that discussion is a lot more nuanced in terms of how do we design or architect what that base layer looks like and how it even works.
Cool, thanks. Do you have some basic principle of the base layer? For example, when you set up the structure of the base layer, do you intend to have free market, arbitration body, or what's your basic direction?
Okay, so there's two answers here. One is, the system as it's been proposed today, and the other is like my opinion of how it should work, right? So the system as it has been proposed today is that there is a base layer, and the organization or the body that helps facilitate the base layer is called ECAF. Now, the RDRs as written, it kind of sounds like everything just goes through ECAF, but from my conversations with the folks who drafted the RDRs, that, according to what I'm told, is not what they actually meant. They meant that ECAF is the default, but then if you specify some other dispute resolution or arbitration body to handle your dispute, that it would go to that dispute resolution vendor as opposed to going to ECAF. Now, that basically implies that they are contemplating a free market. It just doesn't explicitly say so in the RDRs. If you would ask my opinion of how this works, I think there are maybe a couple concerns with the way it's structured today, and I think there's a couple principles that we need to take into account when thinking about how we want to design or architect the system, right? We want to ensure fairness. We want transparency because the community will want to know what's going on. And the most important thing is we want scalability. Scalability will allow, the most transactional confidence. And I think it's unlikely that EOS is going to be a network that has, the majority of transactions being worth $100,000 or $500,000, right? But those are the kinds of disputes where human arbitrators really come into play. If you have a $20 dispute or even a $2,000 dispute, it may not be worth it to dispute it and go to a human arbitrator, because the human arbitrator might cost a lot. And so the way I see this possibly working is, I think initially it is just right for ECAF to go hire and train human arbitrators, because right now we don't really have any dispute resolution vendors, but that should be a temporary measure. I think more so ECAF should promote a free market and create an infrastructure in which they actively in which they actively tell people, hey, go choose your own dispute resolution vendor from this free market. And if you forget or anything like that, then we will be your default. But even when they act as a default, then I think it's probably a lot more scalable and efficient for them to not necessarily take every case on their own, but to look at the different dispute resolution vendors on the free market and delegate some cases out to those. So they'd be, in some cases, delegating their authority to good dispute resolution vendors. But to the extent that you have, automated dispute resolution vendors, and that becomes a lot more efficient, and then we don't have to necessarily waste resources for ECAF to go ahead and resolve these disputes on their own with human beings.
Cool, agreed. Scalability really is the top issue we need to solve for setting up the basic layer. Definitely. Thanks, Amy.
Yeah.
All right. Thanks, Stephen, for the question. So I see Jem and Dimitri have hands raised up. So Jem, do you want to go first?
Sure. Just a kind of a follow-up to the last question. Colin spoke about the high importance of speed of the dispute resolution process. I wonder if you could speak to that. Do you see that as something which is A, is it as important as Colin mentioned, and B, is it something that is implementable and scalable within a system like EOS?
Sure. So I think speed is definitely a very important principle to take into account. I think people get very, very frustrated if dispute resolution takes longer than they believe it should. I think speed is partially based on the question of what is the size of the disputed amount, right? If you have a dispute of about $20, then that's not that big of a deal. And so to the extent that you make a quick decision, I think the parties would, actually be happy about that versus, let's say you have an enterprise dispute on EOS, and that's worth $10 million. I think they're going to want a lot longer to go in and examine the evidence to make sure that they come to a proper outcome, because suddenly $10 million is at stake instead of $10, right? So I think you do have to look at the particular dispute or transaction at hand. Now, that said, I think transactional competence and speed go hand in hand with each other. And so if we are going to talk about, well, how do we make this scalable and speedy, then I think that kind of goes back to this idea of free market, right? Because, if we're sitting there with, as proposed in the RDR today, with human arbitrators sitting there, maybe it takes them 72 hours or a week or several weeks to resolve maybe disputes that are worth $20 or even $1,000. That's not a good use of time. It's not efficient, and it's frustrating for everyone involved because they just want it to be over. They have other things to do with their life. They have other business to take care of, right? So I think that if you have this free market that promotes competition, when you promote competition, you're also promoting customer service, right? And so you can kind of not force, but encourage these dispute resolution vendors on the free market to provide great customer support, and that includes speed and efficiency. And especially if you're going to have some level of automated dispute resolution, then that should make it a lot faster. I mean, if you have disputed anything on PayPal recently, I mean, you go in, you fill out the dispute resolution thing, and in like 2 minutes, you get an email about what the result should be. And then it asks you from there, oh, are you okay with this result, or did you want to appeal it, right? But it's incredible how fast it happens.
Okay, thank you, Amy. Thanks, Jen, for the question. So I see Dimitri. Do you want to go with your question?
Yes, thank you. Hello, Amy. Hello, everyone.
Hi. I think you're on mute. Dimitri, I think you're on mute.
Dimitri, we can't really hear you.
Hello, hello. I just reconnected. Just dropped down from the call. All right. About the question, for example, we already have side chains in the EOS mainnet, and if there dispute happen on a side chain, there should be some additional organization or forum which will take care about it on the side chain, or it should be ECAF, or it's basically how it should happen. An additional thing, I would like to hear more about automated dispute resolution. Thank you.
Okay, so you want to hear about automated and sidechains. So I think that's a great question, and I think that is a question that we have to ask the community about, right? I think you also have to kind of look at what is the purpose of the sidechain. So, you know, I've not trying to get anyone to be alarmed here, but but you know, I've certainly heard of, for example, people who are thinking about taking the Ethereum network and, you know, forking the code and going off and doing their own version of governed blockchain. If that's what they want to do, then they shouldn't be forced to go under ECAF. But for example, if they want to, you know, take advantage of not just EOS's code, but also the governance layer, and they want to, you know, I don't know, add some more code or do something different with it, then I think they should be free to. So I think you kind of have to look at, I think you have to kind of look at a few examples of sidechains first, and then determine, okay, well, what is best for the community, right? But I definitely think that just as in the free market with dispute resolution vendors, where competition breeds a lot of innovation, I think the same thing over here. You also mentioned automated dispute resolution. So, you know, I'll say that when I first read the RDRs, I was pretty surprised because I felt like we were going back in time a couple of decades, right? You know, automated dispute resolution or even online dispute resolution has been around for a couple of decades now. And so to the extent that we are only using human arbitrators, we are definitely not taking advantage of advances in technology and more efficient ways that this has been done over the past couple of decades. So, you know, I think you have to first remember that dispute resolution is, it can be a number of different methods, right? It's simply the process or the method in which you are resolving the dispute. So, you know, if you have two people who think that, who maybe they don't care that much, or they've tried to negotiate as much as they can, and they don't necessarily think that a third party person is going to help them, well, maybe all they have to do is flip a coin, and heads is party A wins, B is party, tails is party B wins. And it could be as simple as that, right? So I do see, you know, avenues of dispute resolution as simple as a coin flipping mechanism, right? If you want to get into more complex automated dispute resolution, that would be things, for example, like what PayPal eBay has today, which is, you know, their dispute resolution system handles over 60 million disputes a year. But I think about only 5% of those cases are ever touched by human beings, because they basically looked at all the disputes that were happening on their platform, and they said, hey, what are the most frequent disputes, right? Maybe 60% of the disputes are of this one certain type. If we can find something to resolve that type of dispute, then that makes 60% of our problem go away. Then they see another problem. Maybe that's 20% of the disputes on the network. They create a little bot around that. That makes, a lot of those 20% goes away, and suddenly, there's a lot less that they have to deal with. And I don't think that this will be overnight on EOS. It's going to take time, right? But I think we're definitely going to want to build a dispute resolution ecosystem as quickly as possible to get rid of this crazy queue that's building up, and it's even started today, right? With all these issues around lost private keys or lack of registration when converting over from Ethereum tokens or phishing scams. People are already working on automated dispute resolution. I mean, my company Sagewise, we came up with EOS Verify for the registration issue. I know EOS Authority and EOS Argentina are working on automated dispute resolution things. So, you can create a lot of little tiny solutions to handle the vast majority of issues on the network.
Thank you. Very nice to hear that there is solutions and someone made it before us and someone working on it right now. Yeah, thank you. That's very good answer.
You're welcome.
All right. Thank you, Amy. Thank you, Dimitri. So is there any other questions? I see Yves has his hands up. Yves,
Jem was there before me, so Jem can go first.
Oh, sorry.
No, mine was
Jem.
finished. Mine was finished. I'll lower my hand.
All right.
Yves, thank you, Jem. Thank you. Yeah, it's great that PayPal and eBay have these ODR systems in place, right? Their reality is quite different than ours. So in terms of challenges of implementing such a system as PayPal and eBay currently have in terms of ODR, to adapt it to our reality on the blockchain with block producers and this immutability function, what do you foresee is needed in order to implement such a system in our current reality, if, let's say, we ever wanted to do that?
Sure. One big thing I think is going to be automated enforcement, right? Because if we're going to rely on the block producers to sit there and, manually enforce today, what is it, hundreds of cases, but I mean, maybe a year from now, maybe thousands or millions of cases, that is unscalable for them. I'm pretty sure that's not the job that they thought they were signing up for, right? And so I think that the enforcement side should always be automated unless there is a very good reason for that particular case not to, right? And I think we'll have to come up with a list of, well, when is it a good reason to not have automated enforcement? So that's one thing. The other is that, obviously eBay PayPal is a highly centralized company, whereas this is meant to be a decentralized distributed network. And so not all the analogies carry over so well. Over at eBay PayPal, obviously they can hire and delegate and have a whole team and department that solely focuses on this issue. EOS, on the other hand, either needs to, I don't know, through community funding, somehow promote to its community, hey, we want people to go out there and solve this issue, right? Whether that's taking funds and offering bounties for certain types of problems, problems, or if it means, for example, being very transparent on what kind of issues you're actually seeing on the network, right? Because in eBay PayPal, the only thing that has to happen is, the customer service team has to talk to the dispute resolution team, and they have to sit there and figure out, okay, what are the different types of cases we're seeing here. We may not have that information readily available, and even if we do have it readily available, for example, the developers who are trying to solve this problem may need much more information than what can be published to the public, right? So there needs to be lines of communication with folks who are working on these types of solutions. And maybe it means that you take, 100 different cases of people who have lost their keys, and you anonymize that information about who it is, but then you publicly release the information so that people have an idea of, how they should be building these solutions. Because, you don't want to build solutions for if you don't fully understand the problem. So does that answer your question? I think that those are probably two of the more important things that we have to think about in terms of EOS.
Yeah, there's definitely, I think you touched on the tech portion of what would be required to do so. So in terms of automated block producer input somehow, there's also, like you mentioned, the privacy issues and the more, I guess, governance related issues on how to then make this information public but anonymized in such way so that everybody's comfortable with what has happened. And I guess at the bottom line, as long as the end users themselves are happy. So if there's two people and both of them get into a dispute and both of them at the end are happy with it, then we don't have any issues. In terms of scalability, you also mentioned that not everything would have to be automated. Of course, if we get into large transactions, so large dispute, let's say there is a large dispute of, $5 million, $60 million, whatever it may be, that most likely would get rejected at the first, the second stage, where people would not be happy with automated dispute resolution, and it would either go to mediation and or finally to arbitration, right? So you jump these different stages, because then you would need that human intervention. But I think for small transactions, or for low value transactions, definitely, as long as both parties are happy and the whole process is automated and the block producers don't have to review, 1 million transactions per year, 10 million transactions per year, as long as everybody in the end is satisfied with the results, this is part of what would make the system, I think, viable, scalable, and definitely trustworthy for small businesses and end users alike.
Yeah, and to give you an example, right? When my company Sagewise, we were seeing that EOS was having a whole issue around registration. We built a tool called EOS Verify, but in the exercise of actually building that tool, we had a lot of questions, like what is the exact nature of the problem that these people are seeing? Are there different variations of the same type of problem? So is it really 5 problems, not one type of problem, right? We wanted to be able to, for example, also talk to people who had the problem, so that we could interview them and get their perspective about how they think they got into this issue in the first place. But we didn't really have that, so we just kind of had to guess, do our best guess when we were building this tool of, okay, what's the core issue? I think maybe if we had gotten a dozen cases, or if we were allowed to look at a dozen cases, obviously with identity erased or something like that. That would have been very helpful for us.
Right. Cool. Thanks, Amy. Thanks, Eve, for the question. So I see Achilles from EMAC has a question.
Yes. Hello, Amy. Can you hear me?
Yes, we can hear you.
Okay. I have a small question about the RDR. We know if the parties are not satisfied with the results of arbitration, in the RDR, they can appeal to the final final community, and the final community will give the final results. But in the in reality life, we don't have this kind of system. What's your opinion about this? Is that ECAF to be? It's good that ECAF to be an independent court, or it's just an arbitration organization?
Sure. So, so I think there's the reality of what is today versus what can be in the future, right? Because today there is no technological infrastructure. There's, you know, we're talking about redrafting the RDRs, right? And so today I think you just need an interim solution just to make sure that the network is, you know, still working and cobbling along. So if today, you know, ECAF is that appeals court, then that may be what we have to work with today, right? And if it's all done manually, I mean, you know, until we build this out, that's kind of what you're stuck with, which is why you guys probably want to, you know, figure out what the solution looks like and start building towards that, so that it won't be manual in, you know, 6 or 12 months. In terms of, you know, the overall concept of what this could look like in the future, I think that's a good question. And it really depends ultimately on what we decide ECAF should look like, right? If you look at some of the dispute resolution projects out there today in the blockchain space, the interesting thing that I've seen is that they have all gone out and designed their own appeal system, right? So today, as far as blockchain dispute resolution goes, there are a ton of crowd juries that are popping up. And for those of you who aren't familiar, a crowd jury, it's kind of like Uber of jurors, right? And so if you have a dispute, then you call the dispute and they randomly select 3 jurors from this pool of their own token holders. And those jurors look at any evidence that's submitted, and I guess they like swipe left or swipe right to decide which party should prevail or win the dispute. Now, I think every single crowd jury that I've looked at so far, they all contemplate their own appeal system. So the positive about this is that, you know, if we're going along the lines of this competition route, right? If you are trying to, you know, get to the best system possible, then maybe that does mean allowing all these different dispute resolution vendors to have their own appeal system. And then not only are the dispute systems competing against each other, not only is their customer service competing against each other, but their appeal system are competing against each other. You might be able to weed out a lot faster and figure out a lot faster what works and what people feel okay with. Now, to the extent that you centralize the appeal system for ECAF, then you're still left with that question of how do we make this scalable? Because people out there will dispute a $20 thing that they're not happy with, right? And then we also, I think there's a lot, I think there's a lot of questions to figure out around that, like how do we architect a dispute, an appeal system that is going to be able to handle all different types of cases, all different types of subject matter material, but is still scalable and efficient.
Yes, thank you. Your answer. I also think the article in New York recently said about the free market of the arbitration. So, if the free market arbitration was implemented on the EOS blockchain, and so all the arbitration, I think, is the same. So, the different arbitration organization, if they don't have the appeal system, just one time, the arbitrator get the result. When you can appeal, except have some procedural problems or some other faults seriously, you can appeal to the local court. And I think it's equal. But if only let the one arbitration organization have the appeal system itself, like it have become an independent court, so it may cause the problem about the external court. For example, like a local court, or the government, a police station, when they wanted to interview of something, the disputes on the EOS, how the EOS arbitrators to deal with the external court, because when the ECAF is not legal entity in the real world, it's not a real it's not a real arbitration organization. Maybe it's a harmless registered in the world right now. Maybe how to get the acceptance by the external court and the government, and get the I mean, it's a problem that how to deal the order from external court. What's your opinion about this?
Yeah. So this is certainly a problem today in the real world, right? In my experience, or at least from what I've seen and heard, this is a much bigger problem in Western society than it is in Eastern society, especially in the US. I would actually say it's probably the biggest problem in the US as opposed to any other country, mostly because people in the US treat the legal system like a big game of chess, right? And so they're always trying to go around and shop for the most favorable or the most friendly jurisdiction, or they may just take it to a different court just to annoy the other party, right? It's all gamesmanship. So, I think the community is right in recognizing that this is an issue, right? And to the extent possible, I think it is important for EOS to kind of architect and structure its own dispute resolution to be as self-contained as possible, so that there isn't too much, I guess, how do you call it, interfacing with the real world. Now, at the same time, I don't think that's something that you can completely prevent, right? So, for example, if we have tokenized real estate, that involves the real world. I don't have a good answer for you, because I suspect that when this first dispute comes up, it will be a case of first impression. So what that means is the court will have to look at this for the first time and try and figure out, well, what should be the best public policy? It will also depend on jurisdiction, right? So, for example, if you have a Delaware corporation, Delaware has a very specific law that says, hey, if you do arbitration and you're a Delaware company, then if you try to take that to a Delaware court, we're not even going to look at it. We're just going to throw it out, right? But if you try to take that to a court in California or somewhere else, right? Different states treat it differently. So the question you ask is a very complex one, and I imagine this is probably why ECAF also contemplated having a litigation fund to defend its interests in making sure that any private dispute resolution on its network doesn't bleed into the real world. It's funny though, because so the litigation fund can be a good idea because it advanced the interests of creating this self-contained legal ecosystem, right? But at the same time, if you don't have that litigation fund and you kind of force the parties to go at it on their own, then A, they're paying for it, but B, because they have to pay for it, they might be less inclined to take it to a real world court because they actually have to pay for the costs and the lawyers and all that sort of thing. So the only cases you might end up having in real world courts are the ones worth a lot of money.
Thank you. Thank you for your answer.
All right. Thanks, Amy. Thanks, Achilles, for the question. I see Stephen has his hand raised up, and given that we are getting close to the 16 minutes mark, we're going to have one more question after Stephen's question. Stephen, do you want to ask your question?
Oh, cool. Thanks, Shane. Just really quick. I just wondering, you may or may not know, what's the Constitution? How the Constitution interact with dispute resolution working group? Because, for example, the current Constitution empower ECAF to be the default arbitration body, and in the future, now they're working on what's going to be the next constitution for EOS and how it's going to interact with arbitration and dispute resolution. Thank you.
Sure. I'll tell you this. Right now, I'm not terribly concerned with what the Constitution says because, you know, the whole reason why we're having these community discussions is to figure out what the Constitution is supposed to say and what the dispute resolution system or ECAF is supposed to look like in the first place, right? So to me, I think we should have this discussion as if it's blank slate, as if we can create whatever system it is that we want. Now, once we, you know, figure out what it is that we want, then I think we go approach the constitutional working group and tell them, hey, this is what we heard from the community. These are our findings and recommendations. We're going to have to redraft the aspects of the Constitution that refer to dispute resolution or ECAF so that it goes hand in hand with what we're proposing over here.
Oh, great. Thanks. Very interesting to learn that. Thank you.
All right. Thank you, Stephen. Thanks, Amy. Is there any other questions from the community? Achilles, I see your hands still up. Do you have another question?
No. Sorry.
Oh, that's all right. So if not, I will ask one question, probably, if possible, on behalf of the ECAF and probably for the Mandarin community. Is For the principles, as you are, Amy, probably as you are designing the principles for dispute resolution and on the base layer, is there a consideration particularly or specifically for the Mandarin community that you probably right now have in mind, or you're planning to incorporate?
You know, okay, sorry. So your question is, sorry, can you repeat the question?
Sorry, let me just rephrase the question a little bit. So as you are designing, let's call it the next generation of the dispute resolution system on EOS network, do you plan to incorporate any specific consideration for the Mandarin community, given that we have already witnessed quite a few cases that has been submitted to ECAF for arbitration from the Mandarin community, and there has been quite a bit of discussion in terms of how ECAF is handling these cases effectively and efficiently. So I was wondering, is there any consideration specifically for the Mandarin community and those cases that could potentially arise from the Mandarin community, or in general, non-English speaking community?
Right. You know, I think we definitely have to architect the system so that it is accessible to all different types of people, whether they're English speaking or not, right? Another thing I think to take into account is, you know, one EOS in the US is probably worth, you know, something very different in China as it is worth something very different in Africa. So there's the socioeconomic aspect, right? We obviously don't want to make it so expensive that we, that, you know, maybe we don't want to make it so expensive that people in other countries can't even afford dispute resolution, right? So that's the second thing. In terms of the Chinese community, though, I will say that I think it's very important that, you know, that we properly engage EMAC and the rest of the Chinese community in this whole process of even figuring out what is it that we want and what is a system that is fair and transparent and takes into the account the concerns of all different types of cultures. And you know, I'm willing to say I'm willing to make a personal commitment to make sure that we engage the Chinese community as much as possible.
Yes, thank you, Amy. I think that's very that's going to be very helpful. I think in terms of the community, the engagement and awareness, and probably even education level of how dispute resolution works. Is going to be fairly important. Otherwise, it's just going to become really messy in terms of how our community members is going to engage on the dispute resolution process. Thank you so much today for taking time to answer the questions from both Mandarin community as well as non-Mandarin community. And we're looking forward to have more engaged discussion and hopefully feedback into the working group. We're gonna collect the questions and answers during this call and put them into article and share with the community. If there is any feedback, hopefully we can put that into future discussions.
Great.
All right. Thank you very much. Thanks everyone for joining the call. And looking forward to have more of these meetings coming up.
Thank you, Amy. Thank you, Shane.
Thank you, guys.
And I'll stick around in case Jem has a question.
Yeah, I actually, it's kind of a follow-up to the question about terrestrial courts. One of the basic assumptions has been that because arbitration is well established under treaty in most countries, that there's been the assumption that on-chain arbitration will largely be accepted and by the national courts because it falls under, sort of commercial contractual arbitration treaties that already exist. I'm just curious about your opinion on that. Is that a valid assumption about how we can expect the majority of cases which will be considered commercial arbitration will just be accepted by the courts for anyone who tries to appeal off-chain?
So theoretically, I think you're correct. It should. If you actually look at real-world disputes, right? And I think this is something I heard from the U.S. State Department. I think something like upwards of 30% of disputes, cross-border trade disputes, are never resolved. And there's two reasons behind that. One is because of the efficiency issue, right? Like, if it's only a $1,000 case, are you really going to haul someone overseas and spend $5,000 trying to, figure out or get a resolution to that dispute? So a lot of people just give up. But the second reason is actually enforcement. And I actually think this is where blockchain has a lot of potential, right? If you have on-chain dispute resolution and you have automated enforcement, there's a question of, well, what can I'm going to use your term, terrestrial courts really do? Are they going to issue court orders to block producers in 21 different countries? I kind of doubt that, right? This is a decentralized network, and I think it's going to be, and the block producers might be constantly changing, right? Because they have to get voted in. So I think there's theory, and then there's like the reality of the situation of, okay, like if there's a certain resolution and someone's not happy with it, and they even go to an external court who for some reason refuses to validate that private dispute resolution, well, from a logistical perspective, what are they going to do about it? Like, and I think there's actually very little that they can do. That's why this is a decentralized network. But I think we're wading into very novel legal waters here, and the one true thing that I've learned in law is you can never predict what kind of interesting problems human beings will bring to the surface. So I can't wait to see what kind of challenges arise. Well, I hope that answered your question. It's 10 past the hour. I don't see any more questions, so I'm going to log off. I did record this call on Zoom, so I'll try and get it over to EOS Detroit or Kevin Wilcox to see if they can post it on YouTube. All right, thanks everybody.
Thank you, Amy. Thank you, everyone.
Thanks, Amy.
Thank you. Bye.
Bye.